Greetings to the gods, strength and powers, my brothers, my sisters. All right, so today we're continuing Caribbean Commonwealth by Carmichael and Codaline on trusts. Right, we're continuing the series and we're going into trusts distinguished from other legal relationships. All right, trust distinguished from other legal relationship, guys. So we have bailment relationship, we have agency relationship, we have contract relationship, we have debt relationship, we have powers, we have an administration of estates. All of these relationships that exist in the legal framework of things in the system that we are not even aware of. All right. And the trust relationship is the seed. The trust relationship is at the root of all these relationships. All right. We must understand and comprehend the trust relationship. So we're gonna distinguish the trust relationship from all these other relationships. All right. So we're going through. All right. Let me get my pen. Nice. The characteristics of trusts are perhaps best understood by comparing them with other legal relationships, such as bailment, agency, contract, debt, powers, and administration of estates. The characteristics of trust, to better understand the trust relationship, is to compare the trust relationship to other relationships. All right. So trusts distinguish from bailment. So bailment arises where a chattel owned by X is, with X's consent, placed in the temporary possession of Y. It is similar to a trust in that Y is required to take good care of X's property, but it is dissimilar in the following respects. A. Bailments are recognized at common law, whereas trusts are equitable only. Remember, trusts are creatures of equity. They are a right solely enforceable in equity. Bailments are recognized at common law or statutory law in modern times. All right, that's the law that is common to every man today. All right, the statutory laws. The duties of a bailee are quite different from those of a trustee. The duties of a bailee are quite different from those of a trustee. C. Only chattels can be bailed, whereas any property may be held upon trust. Only chattels can be bailed. So I wanna look at the definition of chattels. I wanna show you all the definition of chattels, because chattels, when used in different schemes, can mean different things in the sense of when it comes to property. All right. So let me get my handy dandy Black's Law. And we're going to look for the definition of chattels. You see, the definition of the words is crucial to comprehending and understanding these texts that we'll be reading. So remember, check out the videos on definitions on my other channel, on my the other videos on my channel, for the definition of these words. All right, so you will get the definitions in collaboration with the knowledge that we're gaining going through this book on trust. So let's see, chattel. So usually plural, movable or transferable property. It can also be personal property, especially a physical object capable of manual delivery and not the subject matter of real property. So that money is not to be accounted goods or chattels, but it is not of itself valuable. Chattels are either personal or real. Personal may be so called in two respects. One, because they belong immediately to the person of a man, as a bow, horse, etc. The other, for that being any way injuriously withheld from us, we have no means to recover them but personal actions. Chattels real are such as either appertaining not immediately to the person but to some other thing, by the way of dependency, as a box with charters of land, apples upon a tree, or a tree itself growing on the ground, or else such as are issuing out of some immovable thing to a person as a lease or rent for the term of years. Thomas Blount, Norman Lexicon, a Law Dictionary, 1670. All right, and there are further explanations of chattel, personal, and real. So what I want you guys to take away from this definition of chattel is that chattels can be a bundle of paper, it can be oranges growing on a tree, it can be a tree attached to land, it can be movable or transferable property, it can be personal property, right? So just remember the definition of chattel. So only chattels can be bailed. So chattels, let's say a bundle of paper. So let's say you have a couple books, right? Or let's say you have a couple receipts for those books. That could be considered chattel, a bundle of papers, all right? So whereas any property may be held upon trust, all right? So D, a trustee is the legal owner, remember legal title, right? Or legal estate of the trust property, and the general property is in him. Whereas a bailee has only a special property in the chattel bailed, the general property remaining in the bailor. Thus, a trustee who sells trust property in breach of trust can confer a good title free from the interest of the beneficiaries on a bona fide purchaser for value without notice of the trust, whereas a bailee who makes such an unauthorized sale cannot pass a good title as against the bailor. All right, so that was a mouthful. So let's see if we can break it down in simple terms. Remember, with pertaining to a trust, we talk about legal estate or legal title, and we talk about equitable estate or equitable title. All right. So in the trust relationship, the trustee is the legal owner. The trustee can confer good title free from interest on the beneficiary. The trustee decide to sell the property because the trustee might have these duties to sell the property and manage the property for the benefit of the beneficiaries, right? So an example of a bailment relationship is one, let's say, take for instance, a pawn shop. Let's look at a pawn shop. So you take your watch or a piece of gold or a piece of jewelry or some valuable property to the pawn shop, and you leave the property or you pawn the property with the pawn shop proprietor. So what you just created there is a bailment relationship. The pawn proprietor is to hold the property upon your return to get your property with your receipt. Another example may be, let's say, a mechanic garage. So let's say you take your vehicle to the mechanics. You leave your vehicle with the mechanics, just as you would leave your watch with the pawn shop. But the mechanic now, in the case of the mechanic, he's to probably fix the engine, repair the engine, service the vehicle, as the case may be. He doesn't have the right or the legal title to sell the property. All he has the bailee has only a special property where he has to hold the property to do something with the property and return it to the bailor. So a mechanic shop and a pawn shop are examples that we can use to think of a bailment relationship. Legal title is not passed to the bailee. Legal title remains in the bailor. All right. So the bailee or the mechanic or the pawn shop owner cannot sell the property and pass good title. If they sell the property, whoever buys the property receives the property with a bad title or a defecting title, and the bailor can recover his property from the one that the property was sold to by the mechanic or the pawn shop owner. All right. So that is a trust distinguished from a bailment. So trust distinguished from agency. The main feature which trust and agency have in common is that both give rise to fiduciary duties on the part of the trustee and the agent respectively. Thus, for instance, neither a trustee nor an agent may put himself into a position where his personal interest might conflict with his duty. For example, by purchasing property belonging to the trust or the principal. In an agency relationship, we have principal and agent. In a trust relationship, we have trustee and beneficiary. Another aspect of the fiduciary relationship is that both trustees and agents are accountable for any profits made by them out of the trust or principal's property, respectively, in the course of carrying out their duties. However, there are significant differences between the two concepts in that. So this little paragraph here, what this little paragraph here is explaining is that the main feature with trust and agency, which trust and agency have in common, that both give rise to fiduciary duties. Right? Fiduciary duties could be a duty to deliver money to someone, pay money to someone, move a property from one place to the other. All right. So that is fiduciary duties. So a trustee could perform fiduciary duties on behalf of their beneficiaries, and an agent could perform fiduciary duties on behalf of his principal. So let's say I give you let's say we work together, and I borrowed $100 from Tom, one of our other co-workers. But Tom didn't come to work today, and I'm not coming to work tomorrow. I could enter into an agency relationship where I could ask you, without stating agency, can you hold this 100 note for me? And tomorrow when Tom comes to work, can you deliver this 100 note to Tom? What we just created here is an agency relationship and a fiduciary duty. The fiduciary duty is the agency relationship is you now, as my agent, hold this 100 for Tom, and the fiduciary duty is to deliver the 100 to Tom tomorrow. After which the agency relationship is terminated. You are no longer holding to me as the principal. Right? So, on the part of the trustee and the agent respectively. Thus, for instance, neither a trustee nor an agent may put himself in a position where his personal interest might conflict with his duty. For example, by purchasing property belonging to the trust or the principal. So if you take the 100, when I give you the 100 to deliver to Tom, and you take the 100 and you go and you spend the 100 and you buy a box of food for $20. You're conflicting your duty by using the property of the principal for your own use. All right, that's a simple example of what could constitute a conflict with your duty. All right, so if you take the 100 and use it, you're conflicting your duty. That is not the duty that was handed to you. You were supposed to give the 100 to Tom. All right. Another aspect of the fiduciary relationship is that both trustees and agents are accountable for any profits made by them out of the trust or principal's property, respectively, in the course of carrying out their duties. So if I give you the 100, and let me say you are a gambler, you take the 100 and you gamble the 100, and you make 150 on the 100. That 150 that you make on that 100, you are accountable for that to the principal or to the trust. All right. So if you go outside of the duty that was conferred on you, hold this 100 for Tom. Tomorrow, give Tom this 100. If you do anything outside of that, you are operating outside of your duties. All right, and you're responsible. to the principal or to the trust as trustee or agent. All right. So, however, there are significant differences between the two concepts in that an agency is a common law concept, whereas trusts are equitable. B, there is no contractual relationship between trustee and beneficiary, whereas there is invariably such a relationship between principal and agent. So in the trust relationship, the beneficiary has no control of the trustee. The beneficiary cannot tell the trustee what to do. The beneficiary cannot advise the trustee how to manage the trust or anything like that. All the beneficiary could do is request an accounting from the trustee. However, in the agency relationship between the principal and the agent, the principal could tell the agent what to do, how to do it. All right. And there is a contractual relationship between the principal and the agent. Okay. So C, a trustee cannot involve his beneficiary in legal liability, whereas the chief function of an agent is to create contractual liabilities between his principal and third parties. So the agent acts on behalf of the principal. The trustee cannot create liabilities on behalf of the beneficiary. So the trustee cannot enter into contracts and make the beneficiaries liable. Whereas the agent can enter into contractual relationship on behalf of the principal with third parties. All right. So that's another clear distinction between the trust relationship and the agency relationship. D, the agency relationship is personal, whilst the trust relationship is proprietary. For many years, in Lister and Co. versus Stubbs was the leading case on this distinction. So if we want to see the distinction of the trust relationship, the agency relationship being personal, while the trust relationship is proprietary. The agency relationship is the agent has a duty to perform, and that's it. The agent cannot do anything outside of the authority of the principal. Whereas the trustee operating on the rules of the instrument that created the trust can increase the trust property, increase the corpus of the trust, invest the trust property, and propriety. By doing that now, the beneficiaries have a proprietary interest in the property. So as the property of the trust increase, the distribution to the beneficiaries also increases. All right. So let's see this case here. So in Lister and Co. versus Stubbs, the plaintiffs employed the defendant as an agent to purchase goods for them. So the plaintiffs, they hire a guy to purchase goods for them. The defendant, on behalf of the plaintiffs, purchased goods from a third-party supplier from whom he received a secret commission of £5,541. So the agent purchased the goods from the third-party supplier and he received £5,000 commission secretly without the principal knowing. The defendant used this sum to purchase property and investments for himself. So the defendant took the 5,000 and he made investments and he purchased property for his benefit. That's the agent, right? The agent now being the defendant because the matter is now before the court. It was held that the relationship between the defendant and the plaintiff was not a proprietary one of trustee and beneficiary with respect to the money, but merely a personal one of debtor and creditor. Debtor and creditor is another relationship that is distinguished from a trust. And debtor-creditor relationship is the main relationship that all of us get caught in on a daily basis when we do any kind of business in commerce. All right. So it was held that the relationship between defendant and plaintiff, that is the agent and the principal, the agent who was hired to purchase goods for them, was not a proprietary one, meaning that the goods that the agent would have purchased, that's it. Anything he make outside of those goods, he doesn't owe to the principal in this case, based on this word proprietary. Not a proprietary one of trustee and beneficiary with respect to the money, but merely a personal one of debtor and creditor. So that the plaintiffs had no greater claim to the property in the hands of the defendant than the defendant's other creditors. So the plaintiffs had no greater claim. So they couldn't claim the $5,500 that the defendant received secretly, just as if the defendant is owing someone who is his creditor, they cannot claim the $5,500 that he collected. However, in the recent case of Attorney General for Hong Kong versus Reed, the Privy Council took the opposite view and in effect overruled the Lister versus Stubbs principle. So now a principle was established in Lister versus Coe and Stubbs, but now in Attorney General of Hong Kong versus Reed, the Privy Council took the opposite view and in effect overruled the Lister versus Stubbs principle. So now Lister versus Stubbs, the principle in that case is no longer upheld. Now we look to Attorney General of Hong Kong versus Reed for any kind of situations that arise where an agency relationship arises and the agent does anything outside of his duties to the principal and makes any kind of profit or investments or anything like that. So in Reed, the Attorney General brought an action of an account in respect of bribes received by R. This case is a very beautiful case in showing of how the court takes cognizance of the conscience and conduct of a man. The conduct and conscience of a man. Equity regards as done what ought to be done, and he who seeks equity must do equity. All right? So in Reed, so now Lister versus Stubbs principle out. Now we look at Attorney General for Hong Kong versus Reed. So in Reed, the Attorney General brought an action for an account in respect of bribes received by R, a former acting director of public prosecutions, paid to him as inducements to exploit his official position by obstructing the prosecution of certain prisoners. So this is a situation where a former acting director of public prosecution received bribes to exploit his official position, meaning to use his office to obstruct prosecution of certain prisoners. So when the files go to the director of public prosecution, whatever would happen, he will do to obstruct the prosecution, to obstruct the prosecution of the prisoner, right? So R used the bribe money to purchase land in New Zealand. So let me say the former acting director of public prosecution received $500,000 in bribe. He used the $500,000 to buy lands in New Zealand. So here what the Privy Council held now. The Privy Council held that since R was in a fiduciary position, so they placed him in a fiduciary position. Now he is in a fiduciary position based on the situation in collecting the bribe, right? The bribe and the property purchase with it were held by him on a constructive trust. And a constructive trust is an equitable remedy. It's a remedial device. So even though you see constructive trust, it's not a trust where it's not a trust that you create, it's a trust that arises by operation of law. So it was held by him on a constructive trust for the government, because he was a former acting director of public prosecution. So when he took the bribe and he buy the land, a constructive trust occurred, and he now hold the property on a constructive trust for the government. And as the land purchased with the bribe money had decreased in value since the date of the purchase, R was liable to account for a difference between the amount of the bribe and the current value of the property. So if the land depreciated in value, he had to pay the difference. If it increased, he had to pass all the money that he would have made on the land. All right. So a constructive trust, as I spoke about it, being a remedial device in equity to correct the conscience of men. Let me give you an example of a constructive trust. Very simple. And we see it every day, but because we didn't understand trust, we wouldn't know that is what we are looking at, right? But I'm sure when I give this example, you always say, Okay, yes, yes, yes. Right. So a constructive trust, let's say I go to the shop with $5 and I go to the shopkeeper and I say, hey, shopkeeper, can I have a solo? And I give the shopkeeper the $5. He gives me the solo, but he gives me back $10. Now I know that I gave him $5 for the solo because it's $5, it's $4 for the solo. So he's supposed to give me back $1 change. But he gives me $10 in return plus the solo. Now, on my conscience, I am aware that he returned too much cash to me. Now, in that instance, having become aware and having knowledge of that transaction, I am supposed to, on my conscience, bring it to his attention that, hey, you gave me too much change. Here, you gave me $10 extra. Take your $10. Now, if I leave there with that $10, what just happened there is a constructive trust by operation of law. Because I now hold that $10 that was not given to me in good faith, and title did not pass to me because I was not entitled to that $10. So that is where a constructive trust arises. So in the event that the shopkeeper realizes that he gave me $10 extra, and he brings it to my attention, and I took the $10, and let's say I took the $10 and I bought a bread or a light bulb or something with the $10. That which I bought with the $10 belongs to the shopkeeper because the $10 was not mine to spend. And that's how the constructive trust is used as a remedial device when you realize that a fraud has taken place. All right, that's just a simple example, right? So Lord Templeman, delivering the judgment of the Privy Council, said, the decision in Lister and Co. versus Stubbs is not consistent with the principles that a fiduciary must not be allowed to benefit from his own breach of duty, that the fiduciary should account for the bribe as soon as he receives it, and that equity regards as done that which ought to be done. From these principles, it would appear to follow that the bribe and the property from time to time representing the bribe are held on a constructive trust for the person injured. A fiduciary remains personally liable for the amount of the bribe if, in the event, the value of the property then recovered by the injured person proved to be less than the amount. That needs no explanation. Clear as day. Equity regards as done that which ought to be done. These are the principles of equity. These are the principles, and principles don't change. Principles don't change. When we understand the principles, everything makes sense. Right? Do unto others as you have others do unto you. What you like for yourself, you should like for others. And what you don't like for yourself, don't do unto others. All right? So that is the explanation of a trust distinguished from agency. Right? So no specific title passes in agency. It's just a duty to perform and a fiduciary duty arises. Whereas in the trust, title is bifurcated, where the trustee holds legal title, the beneficiary holds equitable title, and the trustee has duties to perform, all right, on behalf of the beneficiary whilst holding the property. All right. So trust distinguished from contract. A contract differs from a trust in the following respects. And I just want to say something too, guys. We're gonna be looking at other highly authoritative books on trust. All right, that goes into the explanation of the distinguishment between trust and other relationship. All right. So as I said, I'm reading from this book for the Caribbean so that you can see that trust is recognized in the Caribbean. All right. And you can get the foundation and the introduction to it. Then when we go on to read the other books, because we already know the terms, we learn the terms from this book. and the different definitions, the relationships. When we go on to read the other books, we could just flow through those books because the trust relationship, it's more or less standardized across the Westminster system. All right. So trust distinguished from contract. A contract differs from a trust in the following respects. A contract is a common law obligation, whereas a trust is equitable. Now, a contract being a common law obligation, yes, but in a contract, you can also have duties to perform, and you can enforce a contract in equity for specific performance. All right. But I'm not gonna go into that as we're just dealing with the distinguishment of these relationships from trust. All right. So everyone has a right to contract, and this is upheld by the United States Constitution, right? Section 1, clause 10. Everyone has a right to contract. And in that phrase, you have a right to contract, but you also have a right not to contract. And you also have if you can contract away your rights, or you can contract and keep your rights. All right. But I digress. As I said, I'm not going to go into that. When we get to those points, when we start to go through contracts and different things like that, then we're going to go into in depth on the powers of contracts as well. All right. A contract arises from agreement or consensus ad idem. This is consent ad idem, meeting of the minds, meaning that the parties entering into the contract, both parties must know everything about the contract and agree to it and consent to it. Every word definition, every meaning, every intent and action of each party must be known in the contract. A contract arises from agreement or consensus ad idem. So consensus, meeting of the mind between the parties. And another thing too is a contract is a common law obligation, whereas a trust is equitable. Right? So a contract between two parties, and based on privity of contract, no third party can get involved in a contract. Whereas a trust is a contract between the settler and the trustee, and the beneficiary being a third party could enforce the trust. As I said, I wouldn't go too much into it. I don't want to lead you guys too far off track of what we're focusing on. So I just saying these things, I just plant this seed in your mind for you to get a comprehension. So when we get into those things, you'll see it. All right. So a contract arises from agreement or consensus ad idem, which is consent, meeting of the minds between the parties. A trust may arise by agreement. For example, where a settler covenants with trustees to settle property in the future, or where a company establishes a pension scheme for the benefit of its employees, but most often it will not. For instance, where a testator creates a trust by his will, or where a donor declares himself a trustee of his property for the benefit of volunteer beneficiaries. All right. So that was a mouthful. So a trust may arise by agreement. So I give you a book and I tell you I want my book back in the condition that I gave it to you, please. That's a trust relationship. You agree? Yes, I will return your book in the condition that you gave it to me. That's a trust relationship. When I give the book to you, I'm the settler. I give the book to you as the trustee. I'm the beneficiary who have to get the book returned to me. So that's the exchange of the property and the establishment of the offices of the trust. Settler has the book, transfers it to the one who wants to use the book. That person now becomes the trustee. That person holds the book, must return the book to the settler. The settler is the beneficiary. So, for example, where a settler covenants, we could look at covenant as a contract. So we could say covenant, indenture, right? Contract, with trustee to settle property in the future. So let's say I lucky. I know I real lucky. I play the lotto and I know I'm gonna win the lotto. I'm gonna win 10 million. I could create a trust with trustees and prepare the trust to receive the winnings of the lotto. I sure I'm gonna win the lotto. So I create a trust to settle property in the future. All right. Or where a company establishes a pension scheme for the benefit of its employees. So a company set up a pension fund or pension scheme to benefit its employees. Trust relationship, right? It arises there. But most often it will not. So most often a trust will not, for instance, where a testator creates a trust by his will, or where a donor declares himself a trustee of his property for the benefit of volunteer beneficiaries. Now, this part here may need a little more clarification. All right. And where it says the testator creates a trust by his will, you can create a will trust or a trust by will, right? That is, but that we'll talk about that in when we dealing with estate planning and things like that. All right. Or where a donor declares himself trustee of his property. A declaration is when you declare yourself trustee, that is the only way you can make a transfer within yourself. You can have property and you can declare yourself trustee of that property for the benefit of other beneficiaries, someone else as beneficiary. All right. So when the donor declares himself a trustee of his property, yes, a declaration of trust within yourself where you're converting the property to trust property held in trust by you as trustee for the benefit of another benefit of someone else as beneficiary, right? Is another way that a trust may arise. All right. So C, the right to enforce a contract is a right in personam since, as a general rule, action can be brought only against the other contracting party or parties. In personam means in person. So the right to enforce a contract is a right in personam between the parties of the contract. The right to enforce a trust, on the other hand, is almost, though not quite, a right in rem. In rem means against a thing. So the trust property belongs to the beneficiaries. The trustees just holding it. So if the trustees do anything outside of the trust that they were contracted to do, or they entered into the trust to do, the beneficiaries through the court of equity can do an equitable tracing, trace the property, so it will be a right against the thing. And then the trustees or whoever received the trust property will have to return it, or if they sold it, whatever cost was gained from it will have to return to the trust for the beneficiaries. Since in the event of a breach of trust, the trust property can be recovered by means of the tracing remedy, right? 12. Right? In chapter 14, they spoke about tracing, right? So tracing is an equitable remedy or a remedy in equity. Now there's also common law tracing, right? Common law tracing and equitable tracing, they operate differently. I won't go into it. As I said, as we go forward and we reach that chapter, we'll get more into it. All right. So not only from the trustee, but also from any other person to whom he has transferred the property, except a bona fide purchaser for value without notice of the trust. A bona fide purchaser for value without notice of the trust is what we call equities darling. The equities darling is a bona fide purchaser for value. Someone gives value for the trust property without notice of the trust, and in the case where the trustee breached the trust, that is equities darling. That person, the beneficiary may not have, may not be able to have a remedy against that person to get the property back from that person. But now the trustee now will be held accountable for the breach of trust. All right. So D, valuable consideration. In the law of trust has a wider meaning than in contract, for it includes not only money or money's worth, but also the consideration notionally given in a marriage settlement by the spouses and issue of marriage. 13, right? So valuable consideration. In a trust, in a contract, there can be valuable consideration. However, in the system that we live in at present, there is no money, right? There's no money. So we can't give valuable consideration for contract. What we have is colorable contract. right? But we'll get into that in another discussion. So valuable consideration with a contract, you can give valuable consideration, and what will be accepted as valuable consideration could be different things. What is consideration? All right, consideration could be labor, could be a portion of the property, right? Could be a certain amount of cash, as the case may be. Once it is accepted between the parties, it is contracted. All right. So in a trust relationship arises. Valuable consideration does not um, arise where a trust relationship is concerned. All right. So that is one distinction between the trust and the contract. So if we let's see, third parties. All right. So third parties. All right. Did I explain? Did I go through this part here? Valuable consideration in the trust. The law of trust has a wider meaning than in contract, for it includes not only money or money's worth, but also the consideration notionally given in a marriage settlement by the spouses and issue of the marriage. All right. Issue of the marriage will be the children of the marriage, the issue of the marriage. All right. Given in marriage settlements, when I settle in a marriage, right, by spouses where you give you enter the marriage in your house, you enter the marriage with bank accounts, whatever the case may be. All right. So third parties at common law, the doctrine of privity of contract applies. So at common law, the doctrine of privity of contract applies. Most times when you're doing a course on contracts, they don't ever tell you about privity of contract. Privity of contract means, in a simple example or explanation, if you and I enter into a contract, no third party could have any say or any access to that contract without my knowledge and your knowledge. So if you and I enter into a contractual agreement and you took that contract and you brought in a third party without my knowledge, you breached that contract. That contract is no longer valid. Right? And you will have to perform the full extent of the agreement in the contract for that breach of contract or that privity. This is a key principle of contract that does not be elaborated on and taught when you're doing contract law or you're dealing with contracts. I wonder why. So accordingly, if a contract between A and B is intended to confer a benefit on C, C cannot sue to enforce that benefit as he is not a party to the contract. But in two instances, equity implies a trust in favor of C, thus enabling C to sue as beneficiary to enforce the contract. This is one of the flexibility of a trust. You can create a trust via contract. All right? You can create a trust via contract. However, in relation to the trust via contract, when it comes to the titles is the difference. In the straightforward trust, where you're creating a trust between the settlor and the trustee with the instrument as the case may be, the title is bifurcated. It is established that the equitable title is between the trustee and the beneficiary. Trustee hold legal title. But when you create a trust through contract, both the equitable and the legal title is owned by the trust or can be owned by the trust. But I digress. When we get further into it, when we get further comprehension and understanding of the trust relationship and titles, we will have discussions on this. All right? And it will become much more clear to you guys. All right? So, okay, and it goes into some acts from the Bahamas, Barbados, Guyana, all these acts, Married Persons Act, Trinidad and Tobago, right? It goes into acts pertaining to people who can sue as beneficiary to enforce a contract as third parties. All right. All right. So let's go through it. So So under the Married Women's Property legislation, see for example, Married Women's Property Act, the Bahamas, Chapter 115, Section 7, Married Persons Act, Barbados, Chapter 219, Section 25, Married Persons Property Act, Guyana, Chapter 4504, Section 11, and Married Persons Act, Trinidad and Tobago, Chapter 4550, Section 11. So a life assurance policy effected by a man on his own life and expressed to be for the benefit of his wife and children or any of them similarly where the wife takes out such a policy in favor of her husband and children, created trust in favor of the objects named. Objects, when you're dealing with trust, objects means beneficiary. So these are terms we need to get clear and we need to comprehend, all right? So as I meet them, I'm gonna just clarify it for you guys so you won't be lost. So when you see the term objects, when you're dealing with trust, we talk about the beneficiaries, right? So the trust in favor of the objects or the beneficiary's name. When the assured dies and the policy monies become payable, the monies will not form part of the deceased estate, so they are not liable for his debts. Trustees can be specifically named in the policy or can be named by separate writing. If none is named, the personal representative of the assured will be trustees for the policy monies. And this straightforward. All right, this don't need any explanation as to the beneficiaries enforcing the life assurance contract that was created. Right. B. Trust of the benefit of a contract. A party to a contract may enter into it as trustee of the benefit of it for a third party, or he may subsequently declare himself a trustee of such benefit, in which case the third party may, as beneficiary under the trust, enforce the contract, although not a party to it. In such a case, the trustee can take proceedings as a contracting party to enforce the agreement for the benefit of the third party, and if he refuses to do so, the third party may himself sue, joining the trustee as co-defendant in the proceedings. So trust for the benefit of a contract. So a party to a contract may enter into it as a trustee of the benefit of it for a third party. So let's say you enter into a contract to paint a house. All right. So the trustee, so a party to the contract. So let me say the owner of the house is a party to the contract and he enter into it as trustee of the benefit of it. The benefit of the contract is to paint the house for a third party, right? And let me say the benefit of to paint the house for the third party is for, let me say, his uncle. All right? Or he may subsequently declare himself a trustee of such benefit. So being the trustee of the benefit, the trustee of the right in the contract to paint the house. So in which case the third party may, as beneficiary under the trust, enforce the contract, although not a party to it. So maybe the uncle is an elderly guy, and let's say his nephew probably say, "Hey, I'm gonna organize to paint this house for you, uncle." Right? The nephew enter into the contract as trustee for the benefit of the contract for the uncle as the third party. Right? Or he may subsequently declare himself a trustee of such benefit. Right? So maybe the nephew probably in the future when the uncle pass away, the nephew might get the house, right? Because the uncle has a will leaving the property to the nephew as the case may be. So in which case the third party may, as beneficiary under the trust, enforce the contract, although not a party to it. So the uncle could enforce the contract even though the uncle is not a party to the contract. So in such a case, the trustee can take proceedings as a contracting party to enforce the agreement for the benefit of the third party. So the nephew could take proceedings to enforce the contract as a contracting party to enforce the agreement between the painters for the benefit of his uncle, and if he refuses to do so, the third party may himself sue. So the uncle may sue the painters, right, and join the trustee as co-defendant in the proceeding. So the uncle and the nephew could be co-defendants or co-plaintiffs suing the painters for not painting the house or breaching the contract. All right. Let's say, however, the concept of the trust benefit of a contract has proved to be an elusive one, and it has been suggested that the way in which a court will decide a novel case is almost entirely unpredictable. Novel meaning new. All right, novel meaning new. So if they don't have prior cases that they can read from, and they can see the decisioners make in a similar situation, it may be unpredictable of the decision that is given. In recent times, the courts have shown a marked reluctance to find a trust of the benefit of a contract. So in recent times, the courts have shown a marked reluctance. So they're reluctant to see a trust arising through a contract. All right. In Swain versus the Law Society, these are 1982 case. For instance, the respondents had arranged a master insurance policy for all practicing solicitors under statutory powers. So this is a court case where Swain versus the Law Society. Maybe Swain was a lawyer or solicitor, and he brought a matter against the Law Society, right? The respondents had arranged a master insurance. The respondents, being the Law Society, arranged a master insurance policy for all practicing solicitors under statutory powers, right? So an insurance policy for all practicing solicitors under statutory powers. It had been agreed that the proportion of the commission earned by the insurance brokers would be paid to the Law Society for the benefit of the profession as a whole. Two solicitors who were dissatisfied with the way the scheme was being operated sought to make the Law Society accountable for the commission received. So the solicitors was unhappy, and they decided to bring the Law Society, bring a suit against the Law Society, on the ground that the Law Society was a trustee of the benefit of the master policy contract for the benefit of all solicitors. So they were claiming that the Law Society was a trustee of the benefit of the master policy. So wherever the brokers would have made on the insurance policy, the Law Society, the solicitors saying, were the trustees for this benefit of this master policy contract, right? The argument was based on the fact that the contract stated that the policy had been entered into on behalf of solicitors and former solicitors, which it was contended showed an intention to create a trust of the benefit of the contract. The House of Lords rejected this argument, holding that the wording in the contract did not create a trust either expressly or impliedly. All right, this is key. This is a very critical point here. That it's what the House of Lords said. The wording in the contract did not create a trust, and as we go through the book, you'll see how important certain words is in creating a trust. In Lord Bingham's words 16, it would indeed be surprising if a society of lawyers, who above all might be expected to make their intention clear in a document they compose, should have failed to express the existence of a trust, if that was what they intended to create. So what it's saying here is that these society of lawyers who are expected to make their intention clear, intention is the mind, what they're thinking clear, in a document they composed, so they wrote the document, should have failed to express the existence of a trust. So they didn't express the existence of a trust. They didn't use the correct wording, if that was what they intended to create. If they didn't use the wording, how you expect the court to see a trust if you're using precatory language? Huh? So if you don't word the trust instrument properly, and the trust instrument reach before the court is not going to recognize that trust. Right? And that is what happened in the situation with the contract. So in the Barbadian case of Rochester versus Arthur 17, so IBID at 276 in the same place, 276, the question arose as to whether a third party could obtain the benefit of a life assurance policy in which she had been named as beneficiary. So here, E.S. deceased was, at the time of his death, the holder of 3 life assurance policies, which he had taken out with Manufacturers Life, the first policy, and American Life Alco, the second and third policies. GS being named as beneficiary in all 3 policies. A clause termed the beneficiary designation clause in the Manufacturers Life policy stated, Wherever a beneficiary is designated either in this policy or by a declaration in writing by the owner, such beneficiary will be deemed to be beneficially entitled to the proceeds of the policy if and when the policy becomes payable. So this is a clause that was in the life policy. In the ALCO policies, it was provided that the proceeds are to be divided equally among all persons who are named as primary beneficiary and who survive the assured. That's a clause in the ALCO policy. It was conceded that the manufacturer's life policy, by its wording, created a trust in favor of the named beneficiary. But a dispute arose as to whether the clause in the ALCO policies created a trust in favor of the named beneficiary or whether it was merely an ineffective attempt to confer a benefit on a third party. So if you look at these two clauses, so it says wherever a beneficiary is designated, either in this policy or by declaration in writing by the owner, such beneficiary will be deemed to be beneficially entitled to the proceeds of the policy if and when the policy becomes payable. This clause covers it. It expresses a trust in favor of the beneficiary. This clause here, the proceeds are to be divided equally among all persons who are named as primary beneficiary and who survive the assured. This is much more vague, so they don't see this creating a trust relationship to a third party. So CHJ applied the principle of the law that a trust of a life assurance policy outside a married woman's property legislation was not to be inferred from a general intention to benefit a third party, but only on language clearly revealing an intention on the part of the life assured to declare himself a trustee of the benefits of the policy for the named beneficiary. The beneficiary clauses in the ALCO policy did not reveal any such intention, he said. All right? And he gives his explanation here. The submissions in connection with the absence of a similarly worded beneficiary designation clause in the ALCO policy document argue that since the policies issued by ALCO did not come within the scope of the Married Women's Property Act, and remember, I told you guys this book is on statutory trusts pertaining to the acts of the countries, right? A trust was not created in favor of the named beneficiary. Counsel further contended that a trust of a policy is not to be inferred from a general intention to benefit a third party, but only on language clearly revealing an intention to create a trust. So it's not speculation. And they're not going to create a trust based on precatory language, meaning that you didn't clearly state your intention. All right? This submission, in my view, raises the fundamental question of whether the wording of the section designated beneficiary in the ALCO policy document is such as would lead a court of equity to the irresistible conclusion that by naming his mother beneficiary, Elroy Scantlebury evinced an intention to declare himself unequivocally as trustee of the benefits of the policies of his mother. In considering this question, it is to be borne in mind that men often mean to give things to their kinfolk. They do not often mean to constitute themselves trustees. Indeed, in his work on life insurance law in the Commonwealth, 1984 at page 116, so that's our book, Denbow, while dealing with the rights and status of beneficiaries under a contract of life insurance that does not come within the provisions of the Married Women's Property Act, states, the position of the named beneficiary at common law under a life policy is governed by the well-established rule of English law that a third party not being a party to a contract made in his favor cannot enforce it. And guys, this is clearly straightforward. The inability of the named beneficiary at common law to use on the policy has never really been recognized in the countries of the Commonwealth Caribbean, notwithstanding the fact that the English common law applied to these countries. This fact is attested to by the existence of a considerable number of policies in which an individual, not being the spouse or child of the assured, is named as the beneficiary with the intention and expectation that such person shall be entitled to receive the policy proceeds on the death of the assured. This situation has come about because of the strong influence of Canadian life companies and to a lesser extent American law on the Caribbean life insurance market. In both of those countries, the right of a named beneficiary to sue for and receive the policy proceeds is well established. In Canada, while at common law English, law applied and the named beneficiary had no right of action against the insurer for the recovery of the policy proceeds. He has been given a statutory right to sue for the insurance money in his own name. Whereas in America, the courts have for over a century recognized the right of a named beneficiary to sue in his own name to enforce a life policy. In the Commonwealth Caribbean, apart from Section 139 of the Insurance Act of 1980 of Trinidad and Tobago, there is no equivalent of the Caribbean statutory provision, and therefore the position of the named beneficiary is governed by the English common law. Not only does the foregoing passage clearly reflect the settled principle of law that a stranger to a contract cannot sue upon the contract, privity of contract, even though it was made for that person's benefit, it also reveals the background to and the effect of the named beneficiary appearing in the clauses of life insurance policies issued by North American companies. Thus, in the absence of an appropriately worded statutory provision, in the legislation of states of the Commonwealth Caribbean, it would appear that a named beneficiary, as in the instance case, must establish that the language adopted by the policy document in relation to its beneficiary designating clause is so structured as to lead a court of equity on a true construction of that language to the conclusion that a trust was created. This is certainty to create a trust must be found in the language employed in the naming the beneficiary. And if you don't know about trust, you will not be aware of this clause and you will not know how to ensure that this clause is in that life insurance policy. And if it is not there, whoever wrote that policy could be clearly intended, maybe deemed to be intending to cause that policy to revert to somebody else and not the beneficiary. This is why we need to understand trust. So Rees J, in the course of his judgment in Rajkumar versus First Federation Life Insurance Company Limited, observed that it must be borne in mind that equity leans against implying a trust for the benefit of a person, not a party to the contract, unless there is a clear intention to create one. And all this is case citations that you can cite to enforce your point when you're talking about intention to create a trust. Right? So turning my attention now to the effect of the wording of the section this designated beneficiary in ALCO policy document and what the learned judges do. They build up, they show you where they are pulling their point of view from based on past experiences, right? So they would have give you their take on from different cases and different situations, different countries on the intention to create a trust and the clause, the beneficiary clause in the assurance policy. Now they go into the point in the ALCO policy now to make it clear as to what they are, where their position is and how they see the clause in these policies. So turning my attention now to the effect of the wording of the section designated beneficiary in the ALCO policy document, can it be truly said that by naming his mother beneficiary in each of the clauses of the policies as presently worded, Elroy Scantlebury evinced an intention by that act done to declare himself trustee of the benefits of the policies for his mother? Question. In seeking to answer this question, it must also be borne in mind that the three policies effected on the life of the deceased Elroy Scantlebury were taken out by him as a single man at the ages of 21, 22, and 26. I find myself unable to come to the conclusion that Elroy Scantlebury, at this tender age, intended during his lifetime to deprive himself completely of the benefits of the policies, or to constitute himself a trustee of them for the benefit of his 62 to 66-year-old mother. So what the judge is saying here now, based on the wording of the document, he cannot see that this young man at the age of 22 and 26 wanted to make himself trustee to benefit his 62 or 66-year-old mother. So accordingly, I take the view that the naming of his mother as beneficiary in the clauses as they are presently designed in the two policies issued by ALCO cannot be construed as an intention on the part of the deceased Elroy Canterbury to constitute himself a trustee for his mother. So no trust was created based on the wording in ALCO policies. In Barbados, the legislature has introduced welcome statutory reform in sections 114 to 21 of the Insurance Act 1996, the effect of which is that it is no longer necessary to construe the language of the particular policy in order to find an intention on the part of the life assured to declare himself a trustee of the benefits of the named beneficiary. And that's another thing that happens, right? We have the separation of powers where we have the executive, the judiciary, and the legislature, all right? Each of them, the separation of powers means that none of them can interfere with the other and they can't influence the other directly. But when judgments are passed in the court, in the case of this one, what it says here, the legislator went back to the drawing board, and based on what the judge said in this case, they rewrote the legislation of the Insurance Act of 1996, right? The effect of which that it is no longer necessary to construe the language of the particular policy in order to find an intention on the part of the life assured to declare himself a trustee of the benefits of the named beneficiary. So it's no longer necessary. So by section 1142, the policyholder may designate a named person to be the beneficiary under his policy. By section 120, such beneficiary is given the right to enforce payment of the insurance monies, notwithstanding the lack of privity of contract between himself and the insurance company. So they give the beneficiary out under these sections in the life insurance policy that the beneficiaries can enforce the trust, even though even though they lack privity of contract. And by section 121.1, any money payable under the policy does not form part of the insured's estate and is not subject to the claims of his creditors. So they pull the policy based on these sections here in Barbados, right? They pull the policy and secure it for the beneficiary. Similarly, provisions have been enacted in Jamaica in the Insurance Amendment Act 1995, which provides in section 2 that an insured person may designate a named beneficiary to receive the proceeds of a policy, and monies payable under the policy shall not form part of the insured's estate nor be subject to creditors' claims. Right? It remains to be seen whether other Commonwealth Caribbean jurisdictions will introduce much needed statutory reform on these lines. So Jamaica and Barbados went back to the drawing board and they passed the policy to protect the beneficiaries, even though they are third parties and don't have privity of contract, to be able to receive the distribution of the assured policy, and the policy is not subject to the insured's estate and is not subject to the claims of creditors, meaning that the creditors of the deceased cannot claim the insurance policy away from the beneficiary, third-party beneficiaries. So Jamaica and Barbados made it so that the beneficiaries will benefit from the insurance policy that was taken out for their benefit. All right. So we covered trust distinguished from bailment. All right. We covered trust distinguished from agency. We covered trust distinguished from contract. And contract was a mouthful. All right. So it is clear and distinguishable that trust operates solely in equity. Right. And we see the difference between contracts, bailment, and agency. So, guys, any questions? You can post your questions in the comment, down in the comments. Right? Like, share, and subscribe. Stick with me on this journey, as I say. Remember, strengthen in body, powers in mind. All right? We're going to continue from trust distinguished from debt on the next occasion. As I said, we're taking our time. We're going through this book. On completion of this book, we're going to come out on the other end with the complete knowledge of trust and estates, in addition to the other books that we're going to be reading and studying from. All right. Check out the videos on my channel, the other videos on the terms, the definition, trust terms definition, the fundamentals. Check out those definitions so that we can make the comparison so you can get the comprehension, the understanding of the terms pertaining to trust and estates. All right. Thank you for your patience and your time. All right. See you on the next one. Stay up.